Hertz here to speak to us as part of our 2010 Fiscally Fit initiative. Fred is a well-known Bay Area lawyer who specializes in legal and financial issues pertaining to same-sex and unmarried straight couples. He has appeared on the Oprah Winfrey Show, the Today Show, NPR's Talk of the Nation. He's regularly quoted as an expert in these regards in publications like the New York Times, Harper's Magazine, the New York Observer, The Advocate, Out Magazine, and other publications. He's a graduate of the University of California, Berkeley School of Law and has been practicing in the Bay Area in Oakland since 1990?
1982.
1982. All right, good to know. He is the author and co-author of several books, and please join me in welcoming him to Google. Thanks.
Thank you so much. It's a real pleasure to work at a place that is gay-friendly and unmarried-friendly and non-traditional family trendy. I have to say that I'm a regular Googler, and my last little episode, I was commenting on the Prop 8 trial about same-sex marriage, and about 2 weeks ago, just because I thought I was going to get a question, I Googled, is Vaughn Walker gay? He's the judge who's handling the Prop 8 case, and I think accurately so. There were only 2 entries, because up until 2 weeks ago, there only were 2 blog sites that commented on it. And then, obviously, your machines have been hard at work, because a week later, when a San Francisco Chronicle article outed the judge and I asked the same question, I think there were like 12,000 entries, over a 1-week period. So just thought I'd let you know that your work helps many of us out there. I'm the author or co-author of 3 Nolo Press books. Nolo is a publishing company that's been around for 38 years, dedicated to teaching people how to handle legal issues themselves. And we have a legal guide for lesbian and gay couples that this year is in its 30th anniversary, 15th edition. It's been continuously published for now 30 years. We also have a book for straight unmarried couples called Living Together, a legal guide for unmarried couples. And then my newest book, which is called Making It Legal, is all about all the issues just of marriage, domestic partnership, and civil union. And we have that one for sale here at a discount of $20, autographed copy, and also some coupons if you want to order it. The other books are available at the nolo.com website. So what I want to talk about in about 35, 40 minutes are the issues of being unmarried or domestically partnered or married, both for opposite sex and same-sex couples, and talk about the financial issues, the legal issues, and a little bit on the political issues. Now, one of the reasons that this fits into a financial fitness talk is that one of the core issues is about marriage is about money. And what I try to explain to people all the time is that I'm not talking about the right to marry. That's a political cause that I strongly favor. What I'm talking about is the choice to marry, whether you are straight and have the right to marry, or whether you're in a gay or lesbian relationship and you have the right to marriage equivalent or marriage in California. And while people say it's not romantic, in fact, the major consequence of marriage or state registration is financial. And when someone said to me recently, well, that's not very romantic, I said, wait a second. Isn't taking care of the person you love romantic? Isn't making sure that the person you love has a house if you should die romantic? And isn't setting financial limits so that you don't break up because of money conflicts romantic? I actually think that's part of romance, is caretaking, and issues of money and property are about caretaking. Okay, so, and the other thing which Jeff and I were talking about earlier today is that one of the most interesting studies that have come out around marriage is that married people tend to save more. Now, there's always a causation problem here. Maybe it's just these boring, conventional savers who tend to get married. And these unmarried people are just risk takers. But we don't think so. We think it's actually that when you have someone else who you are responsible for or who can mess up your life, you actually pay attention to them in a different way. So I was noticing one of the signs from the financial fitness talks about credit score. Well, if your spending habits are going to wreck my credit score, I may pay more attention to your spending habits than I would otherwise. Or if your credit card debt is going to cause me to lose our house, I may start caring more about your credit card debt. I've jokingly said that now that gay couples can enter into marriage or its equivalent, people are going to start asking a different set of questions when they meet somebody in a bar. I don't think gay people, when they were cruising in a bar, were asking about credit scores or bankruptcy history the way straight people getting married might ask, or their mothers might ask. So, first, what are the issues particular to straight unmarried couples? So here the real issue is, on the whole, do you want to marry or not? And what's important to know is that as an unmarried couple, and this is true for gay or straight, you have no financial merging unless you do it voluntarily by owning a house together or buying a car together or taking out a loan together. There is something which is called palimony or Marvin claims, and that comes out of a case from 1978 where Lee Marvin's girlfriend sued him. What's great is this is one of these little legal insider things. Why is it that the lead case about unmarried couples is called Marvin versus Marvin? It's because she wanted people to think she was married to him, so she took his last name even though they never married. But in that case, the court said that in California, a partner can sue his or her girlfriend or boyfriend or ex if they can prove a contract, even oral, or other forms of equitable claims. But what's important, the takeaway for this is it is a ticket to a courthouse, but it is not a winning ticket. The rules for unmarried couples are so stringent in terms of actually winning a claim that almost no claimants ever win. So what's important to know as an unmarried straight couple is you own what's in your name, your boyfriend or girlfriend owns what is in his or her name. If you do co-own a property, it's going to be presumed 50-50, and you can make a claim based on an oral agreement, but don't count on it. You need a written agreement. And in the Living Together book, we have sample agreements on owning a house together, owning a car together. And the other piece to know is that, again, unless there's an agreement, and presumably a written agreement, in an unmarried couple situation, neither will owe alimony or spousal support to his or her ex upon breakup. So when you're thinking about your future, when you're thinking about your retirement, if you are an unmarried couple, you really have to think about it as an individual. And the fact that you have loved someone, cared for them, and maybe even helped them in their career is not going to get you anything if you break up later on. So you have to think about your own retirement, your own savings, and your own debts. Now, there are a few places that allow unmarried straight couples to register as domestic partners, but in general, it doesn't get you any benefits unless your particular employer or city gives you benefits. So, for example, Google, as I understand it, does give benefits to unmarried straight couples. So as long as you're at Google, you'll get that benefit. But if your boyfriend works down the block at Hewlett-Packard, you will not have a share of his stock options just because you're a Google domestic partner and getting health insurance benefits. What's interesting is that the state law that allows what we call marriage equivalent does allow older straight couples to register. This is one of these anomalies where people are like, wait. Why is it that in order to state register, you either have to be same sex, or if you're opposite sex, you can register if you're over the age 62? Anybody want? No, there's probably nobody in this room over the age of 62. But does anybody know why there's that distinction? And what is it about Social Security? But it's specifically to preserve your widowed benefits or divorced benefits. There's one of the rules, one of the benefits of marriage, you all are much too young to worry about this, is that if you're you look young, if you are the low earner in your family, the housewife traditionally, and your husband predeceases you, one of the Social Security rules is you can take your husband's Social Security. The idea is if you're the stay-at-home mom or dad, and your husband dies, you are counting on his Social Security as a retired couple, you can elect to take your spouse's Social Security. You can't take both, but you can take the high earners. Well, if you remarry, you lose that privilege. So the reason why older couples were allowed in to state register is so they could get some of the state benefits of domestic partnership and not lose their widow or divorcee benefits under Social Security. It's a very small crowd. Not many people do it. Okay, so the key issues again for straight couples are we going to marry or not? The other thing to know, and this is true for both gay couples, or will be true whenever there's federal recognition, even though there isn't now, is that the tax treatment is very, very different. Now, what's important to know, and I'll just bring this up because it comes up in the decision-making of straight unmarried couples, is that on the whole, there's a tax penalty while you're together and a tax benefit when you die or break up. I find this very interesting. We keep thinking we have this pro-marriage policy. Actually, the way in which straight couples who are married really benefit is when they get divorced. They actually pay a penalty while they're married. Kind of interesting. And the reason there is this penalty is that if you are married, your incomes generally are combined, and for federal purposes, it can push you into a higher tax bracket because you're part of a $300,000 a year couple, as opposed to if one person is making $250,000 and the other person is making $50,000, that $50,000 earner is going to be in a low tax bracket. But once he becomes part of a $300,000 couple, they're each in the $150,000 tax bracket, and higher federal taxes will result. It's not so much an issue on state of California taxes because there's not the bracket shift like there is for federal. On the other hand, should you go through a divorce or have a death, the survivor or the divorcee will be able to get benefits, whether it's spousal support or inheritance, tax-free. Whereas if you're not in a federally recognized marriage, you will start suffering some serious tax problems upon divorce. So ironically, on the whole, when people ask me from a tax point of view, should I marry? I will say, yes, you should, because it will come in really handy if you get divorced. I don't like to say when you get divorced. People don't like to hear people talk like that. So I say if you get divorced. I can't say when you die because people accept that. So that's the core issue for unmarried couples. Oh, and one last thing about unmarried couples. One of the things I work with a lot is the transition from unmarried to married. And one of the complexities, and this is especially true in California, but it's also true in Washington State, that if you get married, your premarital life is controlled by non-marital law, and your post-marital life is controlled by marital law, which can lead to a lot of confusion if there's subsequently a divorce. So if you save money for 10 years unmarried and then get married, the unmarried savings will not be shared. The post-marital savings will be shared. If you're 10 years unmarried and 10 years married, you will be entitled to alimony based on the 10 years of marriage. But if you wanted to make a claim for the earlier 10 years, you would have to make it under a palimony claim. And so for couples that have bought houses or earned money or received stock options, the date of marriage can have a huge effect. Now, this is having a big issue for gay couples who now have the right to enter the marital system, but it's an issue for straight couples who may choose to marry at a certain time or not, and it can have very significant consequences, again, in the event of a dissolution or death. Okay, so that's the opposite sex couples specialty section. Now let me talk about some of the issues that are particular for same-sex couples. Now, California, the best way I can describe it is that there is this room of state marriage. And it's a room that gay couples weren't allowed to enter at all until 2005. And starting 2005, same-sex couples who either had previously state registered or newly state registered could enter the room of marriage via domestic partnership. And once they got into that room, it was the same as being married. Not the same social dignity, not the same cultural legitimacy, but in terms of the technical legal rights, they are the same. Then, to go through the last 5 years in about 2 minutes, we had the marriage door open in June of 2008, and then couples could enter the marriage room through the front door of marriage. And in fact, there was this little legal fiction, which is that if they had entered in the domestic partnership door, they could actually momentarily step out and re-enter through the marriage door, ending up in the same room they were in before. And they could also get married in Massachusetts and other places, and it would be honored. And then within about 5 months, the marriage door closed. That was Proposition 8. And again, what's important is you could still enter through the back door, but not the front door. There's a lot of interesting controversy. I'm not so interested in the social dignity issues as I am in the legal technicalities, because that's my specialty. I once said in a group of people, I don't care if I sit in the back of the bus as long as the bus takes me where I'm going. It was not well received. But the reason I say that, even humorously, is to say you do need to understand that domestic partnership does take you into the marriage room. And I say that also because there are a lot of same-sex couples who think because it is not given the social and cultural dignity, it doesn't have the legal consequences. And let me just say, if you're the high earner who is breaking up with your boyfriend, who now is claiming half of your net worth, you will learn what it means to be married quite quickly. So then, now there have been several challenges to Proposition 8. Unfortunately, the California Supreme Court, which just a year earlier had said there was a constitutional right to marry, a year later kind of forgot about what they had said and said, well, domestic partnership is really enough, and it's okay if the voters take it away. I don't think that was a well-reasoned decision. I think it was a political cop-out. And now there are two avenues of attempts to undo Proposition 8. There is going to be a proposition on the ballot, but it will not be on in 2010. I think it's now close enough to the deadline that I can say that the people who are advocating to get it back on the ballot by 2010 have not gotten enough signatures to get on the ballot, but it will be on in 2012. And then there is the Proposition 8 federal case, which has been fascinating because it's an attempt to use the federal Constitution to undo Proposition 8. And under constitutional law, if there can be greater protections under federal law, they would trump the state rule. Let me say there's been a lot of talk of, oh my God, this is going to end up in the U.S. Supreme Court and it's going to be doomed. I don't think it's ever going to get to the U.S. Supreme Court. And I'll say this, and I may be wrong. I've been wrong on a lot of these issues before. But I think in this instance, if Prop 8 is thrown out, I don't think it's going to be because the court finds that there is a national federal right to same-sex marriage in every state of the country. I think what's more likely they would say is that because California courts legalized same-sex marriage, it was wrong, even under the federal Constitution, for the voters to take it away. And if the court rules that narrowly, then it would only be a state issue. It would be ruled on by the Ninth Circuit, and the U.S. Supreme Court wouldn't have to take the case. The other is if by the time it gets to the Supreme Court, Proposition 8 has been overturned in 2012 by the voters, hopefully, there'll be nothing for the court to rule on. So I actually predict it won't get to the U.S. Supreme Court. We'll see in a couple of years. So the last piece about the Prop 8 problem had to do with, well, what does that mean for people who marry out of state, gay couples? So the Prop 8 case that the Supreme Court, California Supreme Court ruled on, did not issue a ruling on this issue. It was very maddening to people like me who are trying to advise clients. They actually said in a footnote, we're not ruling on it because nobody asked us to. Not quite true, but that was the cop-out that they took. Well, fortunately, the California State Legislature and Mark Leno from the State Senate got a bill passed which says two things. One is couples that married out of state or out of country before Prop 8 passed will be considered married, and couples that marry out of state or out of country after Prop 8 passed will have all the rights and duties of marriage, but not its designation. This is one of these pieces of legislation. It's like, why didn't they call me ahead of time? Because I know what it does mean. It means that if you choose to go to Iowa or New Hampshire or Canada and get married, whenever there's a rule that applies to married people, it will apply to you. You have to go through divorce court. You're entitled to inherit if there's not a will. You have to pay alimony. All those rights and duties count, but not its designation. I'm obsessed, like, well, what do you put on the deed to your house? Bill and Steve, who got married in Massachusetts and have all the rights and duties of marriage, but not its designation, comma, as community property. I mean, what do you put on, when you apply for a loan and it says, are you married, single? I don't think they have an other form. What I've said is write it all out and let Bank of America worry about it. But it's going to be very confusing. My favorite, there's all these discussions going on. What are you going to call this? For those of you who are literary minded, if you remember, Henry James was a 19th century novelist. He wrote a lot about these closeted lesbians in Boston, and they got to use the term Boston marriages. So I like the idea of calling who entered into a Boston marriage. Somebody else suggested slam, something like a marriage. You know, you can come up with a name. But you can now do that. So in California, if you're a gay couple and you want the rights and duties of marriage, you can either state register or you can go out of state and marry. We're actually encouraging people to state register even if they go out of state and marry, so that they will have clarity in the state of California. It's a little clearer for property and other issues. Now, just to give an update on other states, right now we have full same-sex marriage in Vermont, New Hampshire, Connecticut, Massachusetts, Iowa, and within a month we will probably have Washington, D.C. The thing that's confusing about Washington, D.C. is that they did pass marriage, but it has to go through a 30-day congressional hold where anybody in Congress can try to overturn it. We don't anticipate there will be any, and what's important to know is it's 30 congressional days, and actually Congress doesn't actually get together all that often. So even though it passed December 12th, Congress has not met for 30 days yet. It's anticipated to be about March 5th. So when that happens and that passes and there's no congressional override, then there'll be marriage in Washington, D.C., which is, I think, kind of cool. You've got Washington, D.C., where the federal government is. You've got Iowa, actually a very progressive state. You've got New Hampshire, which is not thought of as a very progressive state, having marriage. We then have marriage equivalent, and we had a lot of struggles in the book about how to call these different states. So I've now called it marriage, marriage equivalent, and marriage light. And we have this in the chart in the book. The marriage equivalents are the states where you can enter the room of marriage, but not its designation. It's domestic partnership on the West Coast or civil union on the East Coast. And those states are Washington State, Oregon, California, and Nevada. Good to know you can rush off to Las Vegas and have a domestic partnership commitment ceremony in the Elvis Chapel. And then it also is New Jersey on the East Coast, and now Maine, which had marriage but then was taken away by a vote. Washington, D.C. was going to have, Washington State, excuse me, was going to have marriage, but it got pushed out by the ballot, but the marriage equivalent did survive. So those are the states that have the marriage equivalents. New York is a really interesting state. New York does not offer marriage or domestic partnership, but they, on the whole, recognize marriages or partnerships from out of state. The one area where they don't is around taxation. They still tax people as single because that's something that has to be changed by statute. But as to property and kids, New York is pretty much a recognition state. Let me also just say that the other 37 or so states do not recognize marriage or domestic partnership. There are a few states, New Mexico, Maryland, that are kind of iffy. The reason why this is so important is that if you live in one of those 37 states or you move to one of those states, chances are at the moment, if you're an opposite-sex couple, you're unmarried, you're still unmarried. If you're a same-sex couple, your marriage or domestic partnership will not be recognized. And that's very important in terms of property or estates or powers of attorney if you should move to a non-recognition state. Okay. So what are the key financial and legal issues that couples should be thinking about when deciding whether to enter the room of marriage? So obviously there's a lot of emotional and social issues of, are you a couple? Are you recognized by your family? Are you recognized by your church? I completely honor the importance of those issues. It's just not my territory. So I'm going to just park those out there, acknowledge them, and go talk about the more concrete issues and less spiritual issues of money, property, debts, and the like. So what's important to know is that marriage creates an economic unit. Being married means you are in an economic partnership with your spouse, and when they go out every day, and as I mentioned in one of the book, one goes to the office and the other goes to the mall, they are each doing it on behalf of this economic partnership. And so that income that was earned at the office and that debt that was racked up at the mall are shared. And they are shared at the moment they are incurred. So, for example, if you're the non-working spouse, you don't have to thank your husband or wife for giving you half of his earnings. It actually is half yours the minute it's earned. And you don't have to ask your spouse to pay half of your credit card debt because it was his the minute it was incurred. The concept, and I actually find it kind of both appealing and problematic, is that you're a team. And the team goes out every day and, hunts or gathers or spends, as the case may be, and you do it as a team. And the whole concept of it, obviously, if you think about historically, it was actually designed to protect the non-working partner, generally the woman, so she didn't have to ask her husband for money. It was half hers the day it was earned. Now, what I've just described is the rule in what's called the community property states, which are basically the states that come from Mexican or Spanish heritage. Wisconsin actually adopted it, but all the other community property states are in the western United States, and this is actually the Spanish rule of marriage that got passed to Mexico, that got passed to California, and it's called community property, and it says you form a community or a partnership when you marry, and it's all a team. If you live in the other 35 or so or 38 states in this country, this is not the rule. The rule is you each keep what's yours, but if there's a divorce, the judge can pull from either person's pot as is needed at the time. So it's important to know this distinction. Community property states, it's 50-50, even if one person has inherited wealth and the other one doesn't. If you're in a non-community property state, the division is based more on what your financial needs are at the time of a dissolution. The other principal concept of a marriage or a legal partnership is that you are taking on an obligation that can extend beyond the marriage in both directions, past and future. The idea is that you are taking on this economic partnership. And so, for example, if my earnings, or what I thought were my earnings, are actually community property, my boyfriend, now husband's creditors, can come after my earnings, because remember, my earnings are now half his. So even for the debts incurred before I met him, his creditors can come after what I think of as my earnings. This goes back to this question of the different sorts of questions you should be asking the people you meet. I now have said my new test is you should be watching the mail of your intended for at least a year, although I now just realized I'm assuming that bills come in the mail. Obviously, I'm outdated because I used to say that, you know, if you're getting dunning notice, if your boyfriend is getting dunning notices and you're kind of looking over his shoulder at the mail, you should be able to see to what extent you're looking to marry a deadbeat. On the other hand, now I realize if it all comes through the internet, maybe you need to be looking at your boyfriend's internet for the next year. The other piece of it is that should there be a dissolution, you can be on the hook for support and payment of debts after the relationship ends. Now, a lot of people think that is really a crazy idea. You know, imagine this. You support your partner for 10 years, he leaves you, and then you have to support him for another 5. It's like, whoa, wait a second. But the concept behind it is actually quite important. It's important that people understand it. It is that while people are together, they make decisions as a couple. Somebody might say, oh, since you're working at Google, I'll become a school teacher. You know, since you're working at Google, I'll become an artist. Well, 10 years later, if there's a breakup, that artist, that school teacher, is very vulnerable. The other, which again, if you ask a lot of couples breaking up, they will often disagree about this, but again, the fiction or the myth is that to be a high earner, you gain from the love and support of your partner. Again, we're going back to a family, a heteronormative tradition, but the idea is that corporate executive wouldn't have been able to get up in the morning. Obviously, you, as I saw today, you have laundry and food service here, but traditionally those were provided by wives, and so the corporate executive could work the 12-hour day because his or her spouse was taking care, or raising the children, or taking care of the house, or doing these things. And, you know, as anybody with kids and a complicated life can tell you, having 2 overworked parents, you know, is crazy making. And so the idea is that the high earner is in part a high earner because of the love and support of the spouse, and therefore it's only fair, even after a breakup, that there be some financial help to soften the blow of the dissolution. So there actually is a valid policy reason for these rules. Oh, one thing I forgot to mention for unmarried straight couples, California does not have common law marriage. Common law marriage is the notion that if you live together and act married for at least a certain number of years, you can be sort of drifting into the marriage rule even though you never got legally married. California does not have that. There only are about 7 states that do. So you should never assume that just because you cohabit for a certain number of years, you are treated as married. Okay, so the last topic I want to talk about in this beginning time, and then I'm happy to take questions or talk further, is what does it mean to be in a same-sex marriage or domestic partnership now that we still have federal non-recognition? 14 years ago, there was a law passed called the Defense of Marriage Act. You can think to yourself as to what it was being defended against. but it said that the federal government does not recognize same-sex marriages or partnerships of any kind. So now that there is state marriage or its equivalent, a same-sex couple that enters into a marriage or its equivalent is still going to be federally single. Now, for anyone who is in the financial world or the insurance world or the legal world, this is a real brain teaser and twister. I jokingly have said to people in this field, every night before you go to bed, say, California married, federally single. And if you say it every night before you go to bed, after about 3 months, you start having these folds in your brain where you can process it. The reason why it's so hard is that everything from financial planners to tax accountants has always said, well, married people have community property, unmarried people don't have community property. Well, now we have federally unmarried people who have community property. And for anyone who is in a state-registered domestic partnership or a same-sex marriage, doing anything that intersects with the federal government is horrendously complicated. So, for example, and I have to say that it's a lot easier now than it was 2 or 3 years ago, and because even people like Intuit have figured out a tax program for gay couples. The problem is that the entire state tax code is built on the federal tax code. And throughout the state tax code, and if you fill out your tax returns, it says take line 42 from your federal tax return. Well, the problem is if you're state married and federally single, what do? Well, in a word, what you have to do is create 2 federal sets of returns. One is single, one is married. Use the dummy return you created as married to create your state return, and do your as single for the federal filings. But that's just the beginning. Let me give you the example I'm dealing with right now. This is your little brain teaser of the day. Couple gets divorced. Bill is buying out Steve's half of the house that they own. They've owned it for 20 years. There's a whole lot of appreciation. Well, under state law, they're considered married. So it is an exempt transaction, meaning Steve doesn't have to pay any taxes on the money he gets from Bill. But Bill does not get a step up in basis. So when Bill sells the house in 10 years, he has to pay taxes not only on his half, but on Steve's halves as well. Because his basis, which is used to calculate housing, does not go up. And this would be true for a straight unmarried couple under state law as well. I'm sorry, under federal law as well, because they're an unmarried couple. But in California, Bill and Steve are treated as married under state law. Well, when it comes to the federal law, they're not considered married. So if Steve gets more than $250,000, which is the residential exclusion, he now has to pay capital gains on that money. But the money that Bill paid to Steve, he can use as an increase in his basis in the house, so that when he goes to sell the house 5 years from now, he pays less capital gains. Follow that? So that means that when Bill goes to sell the house for 5 years from now, his state tax analysis as to what capital gains he owes is completely different than his federal capital gains. Well, every accountant in town has, if you have an accountant and they keep track of these things, they don't keep track separately for federal and state. They just have a basis for the house. Well, you now have a federal basis that's different than your state basis. Another example is if Bill and Steve agree that they're going to wait 5 years before they sell the house because they want the market to go up, but Steve moves out, he will lose his federal exclusion from taxes, because under federal law, you have to sell within 3 years of you moving out. But if you were straight and divorced, there's a rule that says if your deferral of the house sale is in your divorce decree, the 3 years doesn't start running. So the consequences are different state and federal. Well, those are just a couple of the examples of how complicated this is. But federal recognition is not just about taxes. It also means you don't get this widower's benefit from your Social Security because you're not in a federally recognized marriage. It means you don't get to petition to bring in your fiancé or fiancé from a foreign country because you don't have that benefit. And when you talk about children and the issues of parentage, from a federal standpoint, unless you have adopted your partner's child, you won't be considered the legal parent of your partner's child, which can have all sorts of consequences in terms of Social Security and immigration and things like that. Let me just say there's one good ruling on Social Security on this, but in general, you're not in a recognition state. Now, that dilemma of the lack of federal recognition spills into all sorts of things. IRA rules, home loan rules, credit card liability rules. Almost all of these are federally regulated. So whenever you deal with the federal government, you're not going to be in a recognized relationship, which can create all sorts of problems. And this problem is only going to change when the Defense of Marriage Act is repealed by Congress, which might happen in the next 3 or 4 years. I don't think it's going to happen in the next 1 or 2 years. And also could happen by a court throwing it out. And there is a court case in Massachusetts seeking to do just that. So let me stop at this point, and before we wrap up and talk about financial planning and legal issues, any questions people have about any of the things we've talked about, or questions about things I haven't talked about? Yes. Yes, please use the mic because there are people listening to this through an audio connection.
So I'm currently living with my girlfriend, and we're talking about getting married. And she's a PhD, and she has a tremendous amount of academic debt. If we get married, would I be on the hook for that academic debt as well, because it was incurred before our marriage?
Yes. Well, the answer is your income would be on the hook. If you have savings or stock options that you acquired before marriage, that would be your separate property, and her creditors could not come after that. So if you have assets or savings or stock now, you'd want to keep it insulated and not commingle it. But if you married, your post-marital income is community property, just as hers is, and her creditors, including the student loans, could come after your income as well as hers. Yes. There's one way out of this, and I didn't mention this earlier, is that many of the marriage rules can actually be opted out of through a prenup. And so a prenuptial agreement or a pre-registration agreement, you can actually do an agreement in your situation where you would agree, or she would agree, that your income is separate property and not community property. And if you actually did such an agreement and completely abided by it, means no shared savings, no shared credit cards, you each pay half of the mortgage out of your separate checking accounts. If you have such an agreement and you maintain it, then her creditors could not come after you. On the other hand, if you got divorced, she couldn't come after you either, because what goes around comes around in that way. So it can be protected in that way.
Well, we already have a shared credit card, so that's going to be.
Well, you'd have to stop that. You could stop that. But yes, in the absence of a prenup, your income can be tapped by her creditors. And let me just also say, I regularly counsel couples to say, have a big party, have a commitment ceremony. But look, if right now you have the privilege of your income not being tapped by her creditors, why give them your income voluntarily? It may make sense to defer marriage or do a prenup to avoid that problem.
But I couldn't do a prenup just against that debt.
No, you can't say it's all shared unless, B of A comes after you. Yeah.
Hi. You mentioned that there was talk in the recent past of people dissolving their registered domestic partnerships when they could get married. Can you expand on why people were doing that, or if that's
Oh, I didn't say they were
inaccurate?
dissolving their domestic partnerships. I said they were in registered domestic partnerships and they were also getting married.
Okay.
In California, and it's true in Washington as well, you can marry the same person you're domestically partnered to. It merely reaffirms the rights you already have. You don't have to dissolve your domestic partnership as long as you're marrying the same person. If you have a state-registered domestic partnership and you want to marry someone else, then you have to dissolve it or it's bigamous.
I have heard of talk through the grapevine of instances in which people would dissolve their registered domestic partnership before they got married.
To the same person?
Yes.
Well, there are some people who did because they were offended by the stigmatization of that second-class status, and there were people who wanted to limit the time period because they had been registered for 5 years and now they were going to be married, and they didn't want the marriage rules to apply retroactively. So they dissolved their domestic partnership and then got married.
Okay.
The one thing that actually is tricky, let me mention, this is actually one difference between domestic partnership and marriage. Domestic partnership has this archaic sort of artifact of an old system where if you have no debts, almost no assets, no kids, and have been together less than 5 years, which, as I say, applies to probably about 2 couples, you can dissolve your domestic partnership by simply filing a piece of paper with the Secretary of State, and you don't have to go through the court dissolution process. There is no marriage equivalent of that. So that is one area where some people are dissolving their domestic partnerships when they still qualify for that, and then later marrying because it cuts off the time period controlled by marital law. Yes.
If you have a legal domestic partnership or civil union or for a same-sex couple or a marriage, whatever your state permits, and then you go to another state that has something, but it's not exactly the same thing. It's a civil union or a marriage or a domestic partnership. What kind of transferability is there?
The answer is it depends on the state you're coming from, the state you're going to, and the week that you ask me the question. So, for example, New Hampshire now recognizes marriage and domestic partnerships. Massachusetts recognizes marriages but not domestic partnerships or civil unions, although there's a case to try to get them recognized. New York now recognizes some and not others. California now recognizes out-of-state marriages. Nevada doesn't. I really mean it when I say it's week by week, month by month. There is no singular rule. And that's one of the problems of having this patchwork of systems is the confusion around portability. And so, and the answer I also have to say is what's true today may not be true tomorrow. So if you're moving to another state, I don't know what's going to be valid in that state, and you may move to a state that doesn't recognize it now, but 3 years from now does. So we're going to be in a state of flux until there is something singular called marriage. Yes.
Hi. If you have,
Can you pull the mic down a little closer?
I'm sorry. As a same-sex couple, if you have both your domestic partnership and marriage,
Yes.
as far as like for employer benefits,
Yes.
would it matter to change your status from domestic partnership to marriage, or it doesn't matter at all? Or?
Well, here's the answer. In California, with very, very few exceptions, it won't matter. But let me give you one example where it does. One of the odd distinctions between marriage and domestic partnership. In marriage, you don't have to live together to be married. You can have a long-distance marriage. You can marry someone in prison. You don't have to live together. In fact, traditionally, you weren't supposed to live together until you got married. Well, when domestic partnership first got passed in 1982, or 1984 in Berkeley, there was great fear primarily around people with AIDS pretending to be partnered with somebody to get health insurance. City councils were obsessed with this idea that everybody with AIDS was going to find somebody and pretend to be partnered with them. And so there was a residency requirement put into that domestic partnership, and it has lingered now for 28 years. It's still in the domestic partnership. So, for example, if you weren't living with someone, but you were still in a relationship with them, it's possible your employer could terminate your domestic partner coverage on the grounds that you're not living together. Whereas if you were married, there wouldn't be that requirement. That's a small example. The other issue is, and we talked about this, Jeff and I talked about this earlier, and with Bennett, there are some employers that are providing better benefits for domestic partners than they are for married. Because, for example, when it comes to issues like COBRA, the federal government does not require COBRA benefits for divorcing married people. I mean divorcing same-sex married people, but some employers are providing them for domestic partnership. So there could be these little tiny areas. There also might be some, well, let me correct myself. At the moment under state law, there's no difference. In the next few years, if there is federal recognition, it is possible that there will only be federal recognition for married couples, not for domestic partners, because under the current proposal for the repeal of Defense of Marriage Act, they didn't want to create a new federal category. So in that case, if there's a repeal of DOMA and there's federal recognition, and you wanted to be free of the double taxation for domestic partner benefits insurance, or you wanted to have an IRA rollover, for that you would have to get married and domestic partnership wouldn't count. So the answer is, at the moment, I don't think it's a difference. It may become a difference in the future. Well, let me just wrap up by saying that these decisions are not easy. And the one thing that makes it easier for opposite-sex couples is at least there is national recognition if you do get married, and there is federal recognition if you do get married. And other than a few minor changes in marital law, the law today is probably going to be the law a year from now. For same-sex couples, the rules are different from state to state. They're different from state to federal. And they are going to be different from year to year, if not month to month. And so for the same-sex couples, and we talk about this a lot in the book, you need to think about what's most important to you now, what's most important to you in the state you live in now, and make a decision based on what's most important to you now, knowing that as the law changes or your life changes, you may need to change your plans. Let me also point out that for transgender couples, the laws are even more complicated because your legal gender from state to state may be different based on what the state laws are and what stage of transition you're in. And so whether you're treated as an opposite-sex couple or a same-sex couple, if one or both the partners have gone through a sexual transition, can be even more complicated. But let me just end by saying the right to marry is not the duty to marry, and that while everyone, gay and straight, should fight for the right to marry, the question of whether marriage for you and for this particular person you're considering marrying, whether that is right for you, is an individual decision that you need to make carefully, slowly, and with the knowledge that we try to provide you in our books. So thank you very much, and I hope you'll buy a book or two, and thank you for coming.